Hello, welcome to the second part of section 149. Here we will be dealing with section 149 subsection 6, which defines who an independent director is. After celebrating the 72nd Independence Day, it is an apt topic to resume with. So section 149 subsection 6 says an independent director should be a director other than a managing director or whole-time director or a nominee director. He should not be in the position of a managing director, whole-time director or a nominee director. And we have to note that as per LODR, independent director will be non-executive director who does not have power to take executive decisions. So he will not have power to take executive decisions and he will be non-executive director. This is as per LODR. So it will be applicable only in case of a listed company. So an independent director is like a watch person who will be watching over the work done by the other people. The second point says who in the opinion of the board is a person of integrity and possesses relevant expertise and experience. This person who is appointed as an independent director should have relevant expertise. Expertise in the sense the in-depth knowledge and experience in the subject matter in which he is appointed as a director. But we have to note that in case of a government companies, what happens is for a government company in section 149 subsection 6 clause A, for the word board, the words ministry or department of the central government which is administratively in charge of the company or as the case may be the state government. This shall be substituted by notification number GSR 463 E dated 5th June 2015. The next point says an ID, that is an independent director, is or was not a promoter of its CHSA. What is CHSA? Its company, its holding, its subsidiary or associate company. C for own company, H for its holding company, S for its subsidiary companies and A for its associate companies. So we will use the acronym as CHSA. So the independent director is or was not, yani abhi bhi nahi hai, and in the past also he was not a promoter of its company, holding, subsidiary or associate company. It also says is not related to the promoter of director of the CHSA. He should not even be related. The next point says apart from remuneration, the independent director should not receive any other pecuniary relationship with the CHSA during the current year, previous year, first and the second previous year. Okay, this pecuniary relationship the next point says who has or had no pecuniary relationship other than remuneration as such director or having transactions not exceeding 10% of his total income or such amount as may be prescribed with CHSA. So pecuniary relationship means monetary relationship and remuneration means like salary or whatever by names it is called. And we have to note that if in case of a pecuniary relationship, simply utilizing a service which is the ordinary course of business of the company cannot be termed as a pecuniary relationship. For example, in case of SR company has its own petrol pump. Suppose if I am an independent director of SR company, me filling my vehicle with the petrol or diesel of SR company does not amount to pecuniary relationship. And we have to also note that it is not applicable to government companies. And this particular point has to be followed during the current year and 2 immediately preceding financial years. The next point, no relative has or had pecuniary relationship with CHSA or their director or promoter. Now here the point is no relative. Okay, it is not the individual, no relative of the individual has or had in the current. Has means in the current year, had means in the previous year. Here the previous year is the previous year 1, 2 years preceding, that is previous year 1 and 2. There is a proviso here. It states that provided that the relative may hold security or interest in the company of face value not exceeding 50 lakh rupees or 2% of the paid up capital of the company, its holding, subsidiary or associate company, or such higher sum as may be prescribed. And none of the relatives should be what? Should be indebted to the company. That is, its holding, subsidiary or associate, that is CHSA, or their promoters or directors in excess of such amount as may be prescribed during the 2 immediately preceding financial year or during the current financial year. Okay. And the third one says, no relative has given a guarantee or provided any security in connection with the indebtedness of any third person of the company, its holding, subsidiary or associate company, or their promoters or directors of such holding company for such amount as may be prescribed during the 2 immediately preceding financial years or during the current financial year. Or no relative has any other pecuniary transactions or relationship with CHSA amounting to 2% or more of its gross turnover or total income, or in combination with the transaction referred to in subclause 1, 2 or 3. The next point says, who neither himself nor any of his relatives, it shouldn't be him nor it shouldn't be any of his relatives, who holds or has held the position of KMP, that is key managerial personnel, or is or has been employee of the CHSA in any of the 3 financial years immediately preceding the financial year in which he is proposed to be appointed. So he or his relative should not be what? KMP or employee, where in CHSA, that is of the company, holding, subsidiary or associate company. In this case, we also can note that even if you are an article of a company, where like of a firm rather, what will happen is even you will not be allowed to be an independent director, because earlier when you were working for an employer, those people used to be the auditors of the company. So in that case, even articles will not be able to be a independent director. There is a proviso which says, provided that in case of a relative who is an employee, the restriction under this clause shall not apply for his employment during preceding 3 financial years. This proviso was inserted by Companies Amendment Act 2017 and it became effective from 7/5/2018. The next point says, neither himself nor any of his relatives is or has been an employee or proprietor or a partner in any of the 3 financial years immediately preceding the financial year in which he is proposed to be appointed of, where a firm of auditors or company secretaries in practice or cost auditors of the company or its holding, subsidiary or associate company, that is our CHSA. And second, any legal or a consulting firm that has or had any transaction with CHSA amounting to 10% or more of the gross turnover of such firm. The second last, who neither himself nor any of his relatives holds together with his relatives 2% or more of the total voting power of the company. What does total voting power means? In relation to any matter means the total number of votes which may be cast in regard to that matter on a poll at a meeting of a company if all the members thereof or their proxies have a right to vote on that matter are present at the meeting and cast their votes. Neither himself nor any of his relatives is a CEO or director by whatever name called of any NPO, that is non-profit organization, that receives 25% or more of its receipts from the company, any of its promoters, directors, or its holding subsidiary or associate company, that is CHSA, or that holds 2% or more of the total voting power of the company. And last point says, who possesses such other qualification as may be prescribed. Here we have to refer Rule 5 of the Company's Appointment and Qualification of Directors Rules 2014. We also have to see that LODR defines independent director in the same manner, but they have added few things, that the independent director should not be a material supplier, service provider, customer, lessor or lessee. None of them can be an independent director, and he should not be younger than 21 years of age. Also, it is said that it is mentioned in Schedule 4 of our Act. What is Schedule 4? It says about the Code of Conduct of Independent Director. With this, we come to the end of the part 2 of section 149. Here we dealt with who an independent director is. Hope the concept is clear. If you like the video, please do subscribe. We'll be back soon with the continuation of section 149. Thank you.